I will now turn matters over to Attorney John Tarantino.
Thank you, Commissioner. Good morning. On September 5th, 2019, as the attorneys to the Commissioner, my colleague Nicole Benjamin and I conducted a telephonic pretrial conference on this matter. Ms. Wood, on behalf of the proposed intervenors, and Mr. De Sisto participated on behalf of Rhode. At that pretrial conference, Ms. Wood and Mr. De Sisto were informed that Commissioner Infante-Green would afford each of them up to 2 hours to be heard on the motion to intervene and Rhode's objection to that motion. Ms. Wood and Mr. De Sisto were informed that they may each use their 2 hours however they choose. That is, they may call witnesses, cross-examine witnesses, present evidence, or present oral arguments, limited to the issue of intervention. The time used by each attorney will be counted toward their 2 hours. For example, if an attorney cross-examines a witness presented by the other party, then the time spent cross-examining that witness will count toward the cross-examining attorney's time. It's a total of 4 hours, each have up to 2 hours. Before we begin the hearing on the motion to intervene, let me explain what the Commissioner expects will happen today. As the Commissioner noted, in the event that there are objections or motions related to the intervention that would present a legal issue, the Commissioner has asked me to rule on those type things, whether an objection would be sustained or overruled. After Ms. Wood and Mr. De Sisto have concluded their presentations, we intend to take a break, and after the break, the Commissioner will make her decision on the record with respect to the motion to intervene. And then following any ruling on the motion to intervene, we will then begin the show cause hearing. Ms. Wood and Mr. De Sisto have also been informed that if the Commissioner decides to grant the motion to intervene, then the proposed intervenors will be granted intervenor party status, and they may present evidence and oral arguments at the show cause hearing. If, however, the Commissioner decides to deny the motion to intervene, then the proposed intervenors will not present evidence or oral arguments at the show cause hearing because they will not be parties. If the proposed intervenors are granted party status, any evidence submitted in connection with the hearing on the motion to intervene will be treated as part of the record in the show cause hearing as well, meaning it will not have to be presented a second time. At the conclusion of the show cause hearing, the Commissioner will close the record. The Commissioner understands that there are persons here who may wish to be heard. And as she has said throughout the process, she wants to hear what you have to say. Your input, your feedback, your views, your opinions are all important to the Commissioner. So after the record of the administrative hearing is closed, the Commissioner will stay to hear from anyone interested in addressing it. This will be completely separate and apart from the show cause hearing and will not be part of the administrative hearing. While anyone who wishes to address the Commissioner at that time may do so, because it is not a legal proceeding, none of the parties need stay and attend, none of the lawyers need to stay and attend. Comments during the informal discussion will not be part of the show cause hearing record, but should the Commissioner proceed with exercising control over the Providence School District, your comments will be considered by her in the development of the turnaround plan. So with that, we can now turn to the hearing on the motion to intervene. For the benefit of those who are here, the Commissioner has asked me briefly to explain what a motion to intervene is. In the typical hearing, there are usually 2 or more parties, and those parties are usually identified before the hearing starts. In certain circumstances, there are those who are not named as parties, but who claim an interest in that hearing or in that proceeding. And under rules and regulations, those persons who claim an interest have an opportunity to move to intervene, meaning become part of the more formal hearing process. That is what the Center for Justice and Ms. Wood have asked. They are not presently show cause parties. They are claiming an interest in the show cause hearing. They are asking to have an opportunity to be granted party status. So that's what a motion to intervene is. It's different from, you've also probably heard the term intervention into the public schools. That's a different concept. That is the concept where under the Crowley Act, the commissioner may be given power to actually intervene and take control over the Providence School District. That will be the subject for the show cause hearing. So with that explanation in mind, I'm now going to turn it over to Ms. Wood and Mr. De Sisto. I will tell you the commissioner has read carefully and is familiar with the arguments that are set forth in the motion to intervene, in the objection, in the reply memorandum. I will say, and my colleagues agree with me, and so does the commissioner, they were excellent papers, very well done by both sides. She wants to understand your arguments, and from time to time, either she or I may ask questions during the process. So with that, Ms. Wood, I will turn it over to you.